Two things that we've recently heard from our colleagues, other criminal defense attorneys, that we very much disagree with. The first thing is that going for bail angers the prosecutor or the AUSA, and you should not go for bail just because of the worry about their feelings. Very much disagree. Most, probably if not all, AUSAs that we've dealt with understand our function as defense attorneys. They understand that we're there to protect our clients' constitutional rights, and they also understand that we have a job in meeting our clients' expectations as far as what we're supposed to do as lawyers. I've never had an AUSA threaten me that if I go for a bail, there's going to be some sort of blowback or some sort of retribution for me doing so. I disagree very much that you should not go for bail out of fear for how this may hurt the AUSA's feelings. Generally speaking, I think the AUSAs understand what our job is. They understand that it's easier for us to have a relationship with the client, to manage the client if the client is out. So if we have a shot at bail, we're going for it, and I've never even thought about, well, do I hurt the AUSA's feelings by going for bail? The second thing that I recently heard about from another criminal defense attorney that I also disagree with is that it's easier to get a good plea if the client's incarcerated. I very much disagree with that. It's easier to get a good plea if the client is out and about, on bail, on bond, doing what he or she is supposed to while they're at liberty, because you pitch the prosecutor, look, the client's doing so good. What's the whole sense in sending them back in? And the same goes for sentencing. When you're going to sentencing in federal court, and if the client is out and about and doing well on bond or bail, it's much easier to pitch the judge to give a non-jail sentence, because the argument is, judge, this person is doing so good and they're doing everything that has been expected of them, and the case was the turning point in their life, so what's the point of incarcerating the client? And ultimately, if the client's incarcerated, you don't have the same argument, because all that the client could show is, oh, I've been able to keep a job while I was incarcerated and this is my disciplinary sheet. But if the client is maintaining employment, if the client is earning some sort of promotion through their job, yeah, it's a great argument to have for sentencing, and sometimes even for a plea.